A post-conviction relief petition under Rule 32 basically states that you can undo a conviction if you can show that there was ineffective assistance of counsel, if there's newly discovered evidence, or if there's a substantive change in the law. Now, I'm going to focus on this last one, substantive change in the law. Up until 1997, if somebody claimed justification, which could be self-defense, defense of property, defense of others, in relation to a violent crime, they had a defense. But in order to do that, the state had to show that you did not prove it, you being the defendant, beyond a reasonable doubt. Well, that changed. In 1997, they changed it, saying, no, the defendant has the burden to show beyond a preponderance of the evidence that he was justified. Well, it changed back again. In 2006, the legislature passed a statute changing it back to put the burden on the state to prove beyond a reasonable doubt that you were not justified in defending yourself, your property, or others. Well, there's some cases that popped up after 2006, and people argued, wait a second, is this retroactive? Does it go backwards? What's going on? Well, a new case just came out on August 12th of 2010. And this particular case is State of Arizona versus Noel Omar Rios. And that citation number is basically 2010 WL, which stands for Westlaw, 3177495. Or you can go to the Arizona Advanced Reporter, which would be 588 ARIZ Advanced Report, number 5. Basically what happened in Mr. Rios's case, and I'm familiar with it because our firm actually represented Mr. Rios in the pretrial stages of his case. Now, he could not afford us for a trial, or his family could not because the economy changed. So he ended up using a public defender, was promptly convicted at trial and sentenced to 23.5 years in prison. Well, during his trial, he was forced to show beyond a preponderance of the evidence he was justified in using self-defense. Because the law changed shortly thereafter, he filed an appeal, and in that appeal he said, wait a second, I should have been allowed to force the state to prove beyond a reasonable doubt that I was not justified in using self-defense. Well, this came down on the Court of Appeals. They reversed his conviction, and now he gets a new trial. Why is this important? Because the language states, in essence, that anybody convicted at trial after 1997, where the state, or where they had the burden to prove beyond a preponderance that they were justified, they now can file a Rule 32 post-conviction relief petition and get a new trial. That means their conviction can be undone. What does this mean? Well, on old cases, let's say the person's already served their time, probation, and they're off, that person can get the conviction undone. In reality, the state most likely will not re-prosecute them, and that's the end of it. They don't have a criminal conviction. In other cases where people are sitting in jail, they can get a new trial set, and let's say somebody's been sitting in jail for 5 years on a 15-year sentence, the state may decide, you know what, we'll cut you a deal to time served and you're out now. Just plead guilty to the same charge, but you're out now. A lot of people will take that deal and run. For other people, they may say, forget it. I want my trial. I was justified. And if the state, that being the prosecutor, cannot find all of the witnesses because they've moved, because evidence has been destroyed, because people have forgotten what's going on, it's possible they may say, you know what, we're just not going to pursue you anymore. We figured you did 5 years. That's enough. Have a nice day, and it's over. So I would suggest if you have somebody who's in prison who had a justification defense since 1997, went to trial and lost, contact us and we potentially can help them out. If you have somebody who's already done their time, maybe they're on probation, maybe they're off probation, and they just want this off their record so they can get a job, give us a call. We can probably help you out. So I look forward to hearing from you soon. Again, if you don't use us, make sure you look up that case and go talk to a lawyer because it's important.